The last appearance, I was specially appearing to, by special appearance, I was attempting to make a, by a special appearance to challenge the jurisdiction of the court.
All right, Mr. Mann, we are set today for a pretrial conference. You're not here. Why are you not here?
Well, there's a few reasons for that, sir. You know, one of the main reasons is I'd like some clarification on the record to be made without getting arrested due to the last appearance. As you know, was physically unable to get there. You're right about my motion. I didn't prove the just cause. I realized that I had to include some exhibits and proof that of what was going on, and I apologize for that. However, the last appearance, I was specially appearing to, by special appearance, I was attempting to make a, by a special appearance to challenge the jurisdiction of the court due to several issues that have been unaddressed through the entirety of the case. The main ones being the discovery violations, you know, the most recent changing of the discovery files to make all my motions look like I don't know what I'm talking about, and kind of confused a lot of the matters. And it's still the same thing. I mean, just a couple days ago, I got notice that there was another discovery update. I mean, we're well past the motions deadline, and you know, there was a discovery update a week before that, and then another one like a week after, and then now more recent ones. And you know, I just don't really feel like that's really granting me a fair chance at really defending myself when they want to change the names of the files and things like that, as I've like already had submissions that had, you know, certain citations to their body cam footages and things like that that have also been unaddressed. You know, it doesn't really provide grounds for fair defense or a reasonable amount of time to be able to defend myself.
All right, thanks, sir. All right, here's, I guess, the record I'm going to make. We're set for trial to commence on Tuesday. Mr. Mann, I recognize how you are perceiving this, but I think the record is pretty clear. This case has been going on since 2022. By my count, there are at least 8 failures to appear, and that's at least 8 failures to appear in this case. You've after an Arguello advisement, you've agreed to represent yourself. You were advised and cautioned during the Arguello advisement that you would be required to, when representing yourself, to comply with the rules of criminal procedure, with any rules of evidence during the admission of any evidence. That has not actually even become ripe at this point because we've not had any hearings. This matter's been set for hearings to address your motions on a couple of occasions just since I've been the presiding judge over this case. And I believe in, let's see, let me just want to make sure I'm, yeah, on 11/26, that just myself have granted you extensions to file certain motions, giving you specific deadlines. And on 11/26/2025, I made it very clear what the final deadline was going to be for your motions to be filed, specifically 12/12/2025. Then we were scheduled for a motions hearing on 1/9/2026. That was the day that you appeared via WebEx. I found a failure to appear because you appeared via WebEx and did not give a adequate reason. You had indicated that you may be able to get here by 10:30, and I even stayed the warrant to give you that opportunity. Today, we're set for pretrial conference 1 week away from the beginning of the trial date. You're still not here in person. These motions that you keep on talking about could have been addressed appropriately if you would have followed the court's orders during that time frame. And certainly, if there are issues of discovery that have happened that are not in compliance with Rule 16, the court will hear those. But those, again, you've been complaining about, or challenging, I should say, discovery issues, but you never present yourself on a date that we're actually scheduled to address those things. And you have to be here in person. You also have to be here in person for the trial. So again, we're set for a pretrial conference here. I have a jury questionnaire that I'm going to submit to the jury commissioner in preparation for Tuesday's trial. I'm going to bring in 55 jurors for that trial, and the court will be prepared. Well, let me ask the prosecution: is the prosecution ready to go to trial on Friday? I'm sorry, on Tuesday.
People are ready, Your Honor.
All right. So, Mr. Mann, we're set for trial. I mean, this, again, I'll address any pretrial issues or any discovery issues that have arisen in the last 35 days to determine whether there was any discovery violations. One thing you need to understand is the prosecution has a duty to continue to provide discovery. Oftentimes when they provide discovery just based upon, and I don't know how you're receiving your discovery, but again, these are just things I'll consider, and I'm just saying this for your information. Sometimes when they provide discovery, if they're doing it over what they call evidence.com, which is a system that they use to disclose information, sometimes not the new discovery is provided, but then all the previously provided discovery kind of tags along with it, so it's included with it. I will address any discovery issues that may have arisen in the last 35 days if there's any new discovery that may exist. But those are things that I have to address when you're here in person. You're not here in person. I think I know you're aware that you have a warrant based upon the orders, the motions you filed and the last order I issued in this case. But we are set for trial on Tuesday. You have a right to a trial, and the court, and it looks like the prosecution are prepared to proceed on that date. I will provide you with every opportunity to defend yourself at that trial. We will see you on that date. At this point, I don't know that there's anything else I need to go over pre-trial unless Ms. Jones and again, Ms. Jones is here only as advisory counsel, unless there's something in particular that Ms. Jones you think I should be covering, or unless Mr. Duncan wants anything in particular covered. The one thing I will state is just based upon the nature of how things have been progressing in this case, I'm not going to require any witness testimony on Tuesday, so that at least there's a one-day window there for the people to just place any witnesses on call for what's going to happen the rest of the week.
Sorry, Judge, I don't mean to interrupt.
Yeah, no, I'm actually done with that.
Okay, I should have interrupted sooner. If Mr. Mann is not here today, are you finding that it's a failure to appear?
It is a failure to appear. I'm just giving him the information so we can proceed on Monday. He's got a warrant already. So yes, it is a failure to appear. But I still want to pass the information along so we can proceed on Tuesday. I said Monday. On Tuesday's the trial date.
So, excuse me. You said quite a bit there. I didn't really get a chance to respond to anything.
There's nothing to respond, sir. I'm just giving you
I got some things I need to address with the court before we can proceed, sir.
Well, sir, then you need to come to court. We will address those things when you're here in person.
Well,
I'm not going to.
I'm trying to tell you guys need to prove jurisdiction, because there was a period of time I sat in prison for almost 9 months and there was no action on the case. That's a failure to prosecute. And I understand the statutory provisions on speedy trial, but there's constitutional provisions. And if the trial ain't had from the date of the start of the case between 180 days and there ain't good cause shown, that means you guys waive jurisdiction.
I will address, sir. I'm
covered
everything I need to cover.
I'm asking you to address it now, because before we can proceed, I need you guys to prove that you guys have authority to try the case.
Sir, I've already addressed way more than I needed to. You're not actually here. It is a failure.
No, I am here.
I am protecting your right to a fair trial.
You waived my rights to all my motions. Without me even knowing it. I didn't give proper notice of that waiver of rights. You can't just be taking people's rights. The Constitution forbids that, and Constitution trumps everything. It doesn't matter what kind of order or ruling of law. If it's against the Constitution, you know that you can't be ruling like that. So can you address that, please?
All right, sir, what I'm addressing is that you're not here And the one thing I will say is you were on notice as to what the motion's date was, and you failed to appear on the motion's date.
Well,
you have
no,
to be
actually,
in person.
I attempted to appear by
in court.
video because I couldn't get there. And I wish the record would reflect that.
Because
I did try
Sir,
to-
the record is made on this case. Okay. This matter is now in recess.
Okay.
You have a trial on Tuesday. You need
That's
to be
cool.
here in person for your trial.
Yeah, I got you. You don't want to
All
give
right.
me nothing, I got you. That's pretty.
We are on the record with file number 22-186783, JP Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of JP Morgan Chase, P number is 82443.
And your name, sir?
I'm name for the record is I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand. So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I answered. I
asked
sent
you-
the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay. So then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something.
What is that, sir?
I did respond to the courts and to the complainant.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
Okay. Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you want, you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. Number 22-186783. JP Morgan Chase versus Marcus Campbell.
Of course, Your Honor, Jim McCardle appearing on behalf of JP Morgan Chase.
Could I have your appearances?
82443. Of course, Your Honor, Jim McCardle appearing on behalf of
And your
JP
name,
Morgan
sir?
Chase.
Bar number.
Marcus Campbell,
82443.
Special appearance.
And your name, sir? Mr. McCardle, this is your motion.
Marcus Campbell.
Yes, Your
and
Honor.
Special appearance.
Your Honor, we had issued
Mr.
demand to the
McCardle,
defendant
this is your
on March
motion.
15th of 2022. Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22. And then we subsequently filed our motion for summary disposition on 12/15/2022. A series of responses, as it were filed, the last of which is the defendant has a response to plaintiff's counter defendant's motion to strike. Chief among them, in which the defendant has a number of things, but the chief among them, our motion, in paragraphs 5 and 6, the defendant agrees with he's in default. Our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. In our motion, says defendant's answer failed to refute the obligation of the plaintiff. In paragraph 8, our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. He So I'm not sure what that's supposed to mean. The upshot of this is, Judge, there's one other thing. That he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our client, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because the defendant has agreed that he owes the money.
And
Mr. Campbell, your response, and you stand on your pleadings.
I disagree.
Okay.
And I'll stand on my brief.
Prepared to move forward. You stand on your pleadings. This is a motion. Okay. All right, the court's prepared to move forward in this matter. For hearing today. This is a motion for summary disposition filed on behalf of plaintiff and was filed for hearing on December 15th. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that day, the court register of action does following that day that any pleadings were filed by the defendant. Register of action does not appear Michigan court rule that any pleadings were filed by the defendant. Michigan court rule 116.G4 is relevant here. A motion under sub 116 must specifically identify is relevant here, which a motion under sub rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. And when a motion under sub rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denial of specific pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. However, no response was filed to the plaintiff's not relevant to summary disposition. However, in his earlier plea here, which is really not relevant because there's steady over money. They were not again filed in response here. The defendant admitted that he owed the money. Plaintiff is entitled to summary disposition. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition prayed for in MCR 2.116C10. 2219838. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Jamel Campbell special appearance.
First thing I want to know is Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirshenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yeah. Okay, that's fine. We have that. Now, Mr. Campbell, my question to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer?
Right.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as
okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 2219838, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with the genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell,
Yes.
your response, sir.
I sent a brief regarding the denial.
Yes, the
No.
court had the opportunity to read your brief. And I thought it was an interesting set of matters that you set forth here. But I'm prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's
That's all I
filed here, and I see
Yes, sir.
all.
That's all I need to know.
I know, for example, that you cite federal rules of civil procedure. I know,
Right.
for example, that you cite 28 USC 2403. I
Mhm.
further note, you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor. There is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
Right, this is case number 22196913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference. And I'm looking for a Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. All right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right. Anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my fee schedule is on the record. That's all I need.
All right. What I've received, and I've received your answer to the complaint in this matter, as I've indicated previously. That was filed with the court on March the 10th. And that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is, to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13, 23. Defendant in this matter, Marcus Campbell, or anyone representing Mr. Campbell. If you're on the Zoom, please say something at this time. The matter is set on for 9:30 a.m. It is now approximately 9:39. Let me ask you, counsel, have you had any contact with Mr. Campbell? Any response to the motion for summary disposition? Update me on any information that you may have at this time.
No, Your Honor, no response to the motion and no contact from defendant.
It's failed to appear. Moreover, in reading the motion and the issues raised thereby, as well as the predicated history of this these particular transactions herein, I don't see that there is a genuine issue of material fact in this matter, and that defendant, I have to conclude that the plaintiff is entitled to judgment as a matter of law. Moreover, I do not see where a defendant has raised a valid defense to the claim. And so the motion for summary disposition will be granted at this time.